My name is Craig MacDonald. I'm the Senior Records Coordinator at Latham & Watkins, and with me I have...
Rena Hunter. I'm the Global Information Governance Manager.
Great. So we're going to be discussing defensible disposition this morning, and we're going to cover a paper written by the law firm Information Governance Symposium this past year on this topic. So we're pretty much just going to go through the highlights of that paper and talk about disposition at law firms. Establishing a retention or a disposition program at your firm, this is probably a lot easier said than done. It's going to require the involvement of numerous departments and leaders within your organization. So really working with your firm executives to establish a program is probably one of the key starting points. And one of the things that the paper talks about is really selling the program, because it is an investment for your firm. It's going to take time. It's going to require staff time, and it might also require time and money too. I mean, obviously, if you are disposing of boxes, that can be a major cost up front. So kind of selling the firm on the return on the investment in the long run of reducing not only paper storage, but also storage on your electronic systems. And thinking of things like, okay, if we delete information, we're going to, from our systems, searching should be a lot easier for our users. They might not get as many false positive hits when they're searching the document management system because we've deleted a lot of our older Word documents and PDF files. So yeah, this is really a main starting point, is just selling your program. Tips and best practices. I would say having identifying what you want to remove from your firm it can be challenging, and is really a firm-specific decision. But have a plan in place. If you want to target specific clients or matters within your organization, maybe do that. But really consider the needs of your firm up front. There is no one solution to disposition programs. Working with your stakeholders is important. We'll talk about that a little bit later. I think it's really important to have a good relationship with IT. They'll likely be helping you with electronic disposition, especially a core relationship is going to be with your general counsel's office, not just in terms of the disposition program, but thinking of things like your engagement letters and outside counsel guidelines, and being able to push back when clients might want to have specific requirements for the retention of their documents, so that you have that your firm has you're keeping your retention policy intact as much as possible, so you don't have to have as many exceptions. You want to make sure that your retention policy is up to date and keep revising it. And finally, when you're communicating with lawyers in regards to the policy, you want to make it clear to them, and you want to make things easy for them to understand. I think one of the difficult things for retention notifications is they happen years later, and so we're talking about old things a lot of times when we contact people. So making it clear up front what matters you're asking them to review for possible disposition is an important step as well. So we just want to take a moment to highlight the importance of engagement letters and outside counsel guidelines. So one of our core recommendations might be to, in your engagement letters, really carve out your retention policy, and if you can, try to return client original material when the matter closes. That way you don't have to do it however many years later. And if you have language in your engagement letter that states something along the lines of, the client agrees that your firm can dispose of files at whatever your retention date is. And that way, if you don't have to notify your clients of that the matters are up for disposition, that saves you a lot of time in the process. And I think Rena's going to talk about a recent court opinion on that coming up in the presentation. And we just also listed common things in outside counsel guidelines that you might want to consider, in terms of, do you have to return information to the client, what you might have to return, security requirements, notification requirements, keeping files confidential, encrypting things. And so again, I think we talked about this if you were at our session a little bit earlier this morning. Checking these documents too at the final stage of when you're getting ready to destroy information is important. So you don't want to, if you're required to return information to clients in an encrypted format, you want to make sure you're doing that if you're returning files at the disposition through your disposition program. Real quickly, I think we all have different ways to reduce the volume of files. A paper light approach is discussed in the paper. I think it's really important to have filing guidelines for your firm's repositories, whether they're paper, whether they're a DMS, whether you're using shared drives, just making sure people are putting things where they should be. I think we might all have horror stories from doing retention where you find things 10 years after a matter closes and you can't believe it's been where it has been for so long. Dispose of working files after a matter close. That could be a helpful solution to your firm rather than storing, documents that probably might likely be just printouts from a document management system or printouts of emails. If the partner or attorney is just printing out copies of things and putting them in a working file, why save that file to offsite storage for 10 years? So other approaches that are discussed in the paper, scanning, a scan day forward approach, that's, so if we start today, we're going to scan everything from paper into our document management system rather than keeping it in paper format. Some firms try to scan closed matters, files from closed matters. And then some other suggestions in the paper were, purchasing electronic software so that you are, printing less paper, the idea there is. And I think a lot of firms do this, but, having multiple monitors for people reduces, somebody printing a copy to read while they're working on one computer screen. So developing a retention policy.
So when you are developing your retention policy, one thing to keep in mind are the stakeholders at your firm who can assist you. It's definitely the case that having your general counsel or an attorney at the firm assist you with your retention and disposition plan is key. There are a lot of sensitivities and laws and rules, especially by jurisdiction. If you're a global organization, the laws can definitely be different by jurisdiction. So working with the appropriate folks who understand those and can guide you is crucial. Also working with IT so your systems are set up in a way that makes it extremely easy to delete electronic data later on, whether that's using document types or how you folder material, whatever it may be, some sort of classification, maybe it's how you name a document, but working with IT and working with your employees so everyone is doing things in the same way will make it much easier later on. The different types of retention schedules. So the paper goes through to discuss how you might want to approach setting up retention schedules. Certainly you may want to do it by department, such as an HR department or a finance department, because their retention schedules are going to be different from a practice group. It may be that client files you need to save for a different period of time than your tax files for the firm. Definitely things relating to tax are actually usually saved longer than client files in some cases. So you want to make sure that you're working, again, with your general counsel, an attorney, whoever the appropriate resource is at your firm to make sure that you are following local and other rules, laws, and guidelines. Process-based retention schedule, just on the function of the business unit, like I talked about a practice area. So trusted estates documents we know are kept for a while. I've noticed that our environmental and land use department will save things much longer than other groups, and they may even go back and look at something from 20 years ago. So in a case like that, you may want to figure out whether the retention schedule really should be the same as, a general corporate matter that's done where, one company purchased another, and there's nothing to really go back and look at 20 years later necessarily. And then the big bucket retention schedule, typically used when you're creating a policy on client matter files versus firm administrative files. So the three main types of records, you've got your client records. We all know what that is, your work product, potentially original documents, correspondence. Those are some examples, but it really may depend on how your firm classifies documents and what you've determined that you own and what you have determined your clients own. So I would be very careful in how you define client records, business records, finance, HR, BD, things like that. And then personal records, the files belonging to an employee. That's definitely something that you want to make sure you don't have to save forever. No need to save in hard copy files or even electronically personal information. You want that to go when people leave. And sometimes there are folks from, policies past that may have saved material in offsite storage that was simply personal for an important partner, and that individual has left and did not want to take those things, and obviously, that should go. Whether it's sent back to the partner as a gift, but find a way to get rid of that. Ethical rules, jurisdictional, and privacy requirements. These are really important to be aware of. You want to make sure, as I mentioned before, that you're following the laws of the local jurisdiction. Definitely the EU data privacy laws may impact how you handle disposition. It's interesting because if you purchased another law firm and you have merged somehow and you're in Europe, that may impact how you do business. Definitely in Germany, they tend to save documents longer, so you'll want to be aware of where you're operating. And in locations like Paris and Brussels, where attorneys can have personal clients based on how the bar operates there, it may be that those files actually belong to the attorney rather than the firm. So they may have clients that are firm clients and then clients that are personal clients. So understanding how you're handling that different material is definitely important. ABA model rules and state ethics rules, that will definitely guide what you can dispose of and when. We'll discuss an opinion shortly that touches upon that a little bit more. And then the appendix in the LFIGS report that you can get on the Iron Mountain site has a great summary. So we'll just refer you to that because it does have requirements for each state, which is extremely helpful. So I would take a look at that if you're in the process of going through and developing your program. So the Illinois State Bar Association opinion came out this year. It's very interesting because they have said that if you have put in your engagement letter up front, you've advised the client that after X number of years, you are going to destroy their files, that you do not need to give them notice. This is huge. This cuts out a lot of time. I think a lot of us spend a lot of time reaching out to clients who don't really respond on time because they are busy, or they only want part of the file, they're not sure, the person who handled the relationship who was at the client may no longer be there. It's an arduous process. So knowing that you can just delete the files after a certain period of time can be a huge time saver. And I would definitely see how this plays out in other jurisdictions, because I don't think that this will remain particular to Illinois. I think other states will get smart about it and realize that this will be a huge help to law firms. So we'll see how that goes, and as long as clients are aware, then it's fine, because you're giving them notice, say, 7 years in advance or 10 years in advance. At this point in time, if you haven't requested your files, we will go ahead and destroy them.
Okay, so unstructured data and repositories. So I don't know if this is coming up this well. It's just from the paper. But you just want to make sure that you are looking at your repositories throughout your firm to identify where, obviously data is, especially, is it related to a client? Is it related to, firm business or non-firm? Is it, personal in nature? And then, is it structured or unstructured? And you can see that some of them are both. Let's take a, common example. Email is probably both. I think probably a lot of people are using Outlook. It's probably in Outlook accounts, and it's also probably in your document management system. So making sure that you're looking not just at your document management system, but considering timekeepers and their possible Outlook accounts that are either still active at your firm, or how long are you retaining past employees' Outlook accounts and possibly local files in regards to your retention policy. Obviously, that's probably going to vary by firm, but that's something you want to consider with your disposition program. And obviously, in that too, email presents the problem of you usually have a mix of client-specific email. You probably have a mix of firm administrative email. Partners emailing each other related to firm governance. And then a lot of people, as we know, use email for personal use, use their firm email for personal use at times. So that, it's when you're doing disposition, it's important to consider the various types of data and the repositories. And the paper goes into this in good detail as well. But it's really going to, again, vary by firm. Did you want to add something? Yeah.
Yeah, so when we look at email that's not in a document management system, it's interesting because it's a little bit of the Wild West, because everyone manages their email differently. But if you can ensure that your staff and your partners and everyone else are going and organizing things in some sort of uniform manner by client matter number, I think it's a huge help. Certainly, it will help you with your obligations later on if you need to locate material because you need to preserve it, destroy it, release it, at whatever stage of the life cycle you're at. Having a project name that means nothing. I mean, great, you worked on Project Tiger. I have no idea what client matter that is. You may have 20 files with 20 folders in your Outlook account. So being able to dispose of email can be a bit tricky if folks are not organizing by client matter number or some sort of designation that you use within your organization. So it's really key to make sure that you are taking a look at how people are operating. One way to get around that issue is by saying that, key email that's important to the representation has to be in your document management system. But that, again, will, it's an impact on firm culture, and it takes a while to get folks used to that. So that's why I would say, I would shoot for both, getting people to organize by client matter number in Outlook, and then simultaneously trying to get them to put it in the document management system until people are really comfortable with your document management system. A lot of folks still push back, we find, just depending on their comfort level, they like to store data in other places. And so it's just hurting the cats. And then with databases, vendors, and cloud systems, you definitely need to know who owns what, where those are, what you can delete, what the provisions of various contracts are, especially if you have a vendor who's hosting data. What's interesting is, making sure you're keeping track of third-party e-discovery vendors who have client information, especially if your firm has contracted with them directly. How are you keeping track of them so that you can find them later? Is there a general repository with a list so you know to find them later? So those are just some examples.
So disposition processes. There are a couple of different models for disposition programs. The paper recommends that you start with a manual approach and really work and create a workflow for how you're actually going to dispose of files at your firm. I would say most firms probably have a semi-automated approach. A fully automated approach where you have an application that's from cradle to grave managing your disposition program. I think there are some software programs that have tried to address that issue. I don't know how successful they've been, and I think the issue there is every firm has different data, has different systems, and kind of going back to what we discussed in our last presentation, this is really a great process where you can possibly utilize things that your firm already has into the disposition process. So, for example, if you have a marketing department and your marketing department has a program that can help contact clients in terms of notifying them, might be a good idea to work with your marketing group to see how they might be able to help you with notifying clients of files that have met their retention period. And the paper goes into the steps for the disposition process, the general steps. You want to make sure that you're adhering to your retention schedules at your firm. It recommends giving attorneys 30 to 60 days to make exception requests. And I think there's some debate as to whether attorneys have to approve retention or if they can just make exception requests. But that's something your firm is going to have to look at. I think this is an interesting point in terms of time and money. Are you going to destroy at the box level? Or are you going to destroy at the folder level? I think we all know that part of the problem with retention is that we have years of not so great paper storage records in which I think a lot of firms have just various client matters, folders for various client matters in random boxes. So considering how you're going to actually delete your files. And obviously you want to, keep a record of your disposition process steps for each client matter. But just really quickly for the process steps for disposition, you have your identification. So identifying, where you have data, where you have files for eligible client matters, or potentially for administrative departments as well. Analyzing that information. Notification. I kind of think this is potentially a couple of steps. You might have to notify your partners, obviously, and that could be a little bit complicated. If partners have left the firm, then you might have to escalate it to people within the practice group or department chair. The approval process. Again, I just talked about. Do you want to have a formal approval process, or do you just want to give partners the chance to give a business reason to retain records? And also then if you have to contact clients, that would be in those steps. And then you finally get to the disposition point. So it actually is it can be a very long process. And finally the documentation point. And that's kind of, the more you can automate this process, the better. The paper has a workflow that it recommends. And this is, again, from the paper, but, hopefully you're having a system in place where you're automatically closing matters. I know that can be an issue for some firms in terms of when actually matters close, notifying clients of closing, and hopefully, again, with what Rena was talking about, if you're working with other groups at your firm, and as IG or RIM, you're aware that when matters close, and then you can return certain files to the client at that point, and working with partners or paralegals and secretaries to assist with that. That's a great way to get rid of material that you maybe no longer need at that point at the matter close. And then we come down here to, we have our, the matters closed, so disposition triggers, and then you have this IG prep task. So that's where everything's going to be done in terms of getting ready for your disposition program. And again, that can be very, there's so many steps involved in that in terms of notifications and just analyzing and identifying information. So this is the map that they recommend. It is a, can be a challenging to automate this entire process. But, I would definitely take a look at it in the paper and see how it might play out for your firm.
Legacy matters and files from other firms. One of the keys to a good disposition policy is your intake policy. Are you going to take files that you will never work on? Should you take them? Do they create conflicts? So you definitely want to figure out how you're handling files coming in so you are more prepared to handle those files at the disposition phase. Do they have a different retention period because they are not matters that you work on, but you feel obligated to store them for a client because they are bringing a lot of business, and so you may have to figure out how to handle those, and the paper addresses that issue. Also, if you have to take on just legacy files, expressing to departing attorneys that the files they brought must be taken with them or destroyed, because people do bring over things like 5 boxes of sample forms or whatever it may be, and then they want to leave it with you. Well, that should go as a little parting present with the attorney. And lastly, just having a process to destroy files, which is the next slide, outside of the retention period. So if you are called upon to destroy files, whether it's part of a clawback where you receive privileged material that you shouldn't, or any other circumstance, you are prepared. A lot of outside counsel guidelines may say that you need to destroy files at a period of time that is not your retention period, which is interesting because clients can all request something a little bit different. So the paper addresses having a process in place. So I think maybe we'll pause there, and thank you so much for joining us.
Thank you.